Alright, let's talk about the US Constitution. It's that big, important document that supposedly guides the entire country. Think of it as America's instruction manual. If America was a particularly complicated piece of IKEA furniture that occasionally threatens to collapse. Now this manual, written by men in wigs who probably smelled faintly of old cheese and revolution, is surprisingly relevant today. Or at least, people to argue about whether it is, especially when a new president waltzes in and decides to, shall we say, creatively interpret the instructions. The thing about the Constitution is that it's designed to be a bit sturdy, a bit unyielding. It's the bedrock, the foundation, the thing that's supposed to stop the whole American experiment from turning into a reality TV show. Anyway, because it's so foundational, any perceived wiggle, nudge, or outright body slam against its principles tends to get people rather agitated. This agitation isn't new, of course, every administration has its constitutional head-scratchers. But, and this is a big but, like the one Sir Mix-a-Lot appreciates, some administrations seem to generate more of these "is that legal?" moments than others. It's all very dramatic, really. So, what exactly is this US Constitution everyone keeps banging on about? It's the supreme law of the land. It's the big boss. If laws were a rock band, the Constitution would be the lead singer. Drafted in 1787, practically prehistoric in internet years, it lays out the framework for the US government, dividing it into three branches: legislative, executive, and judicial, like a three-legged stool. The genius is the system of checks and balances. Each branch keeps the others from getting too big for their boots. The president can't declare himself king for life, Congress can't pass laws without presidential approval, and the courts can't make up laws out of thin air. The Constitution also includes the Bill of Rights: freedom of speech, freedom of religion, the right to bear arms, protection against unreasonable searches and seizures. These rights protect individuals from an overreaching government. When Donald Trump descended that golden escalator and eventually into the White House, it was clear that Washington, D.C. was in for a bit of a shakeup. Almost immediately, his administration began to test the elasticity of constitutional norms, and sometimes, the actual text itself. The early days were marked by a flurry of executive orders and pronouncements that sent constitutional lawyers scrambling for their textbooks and presumably strong coffee. One of the first major constitutional thunderstorms brewed over the infamous travel ban. This executive order aimed to restrict entry into the U.S. for citizens from several Muslim-majority countries. Critics immediately cried foul, arguing it violated the Establishment Clause of the First Amendment, which prohibits government endorsement of religion, and the Equal Protection Clause. The administration argued it was a matter of national security, a claim that courts initially viewed with skepticism. It was a messy, protracted legal battle, with revised orders and court challenges becoming a regular feature on the news. Then there was the ongoing saga of the emoluments clauses. The concern was that President Trump, with his vast international business empire, was uniquely positioned to, shall we say, blur the lines. The administration mostly brushed these concerns aside, but the lawsuits kept coming. The Trump years were a boom time for anyone with a law degree and a strong opinion on the Federalist Papers. The question, but is it constitutional, became something of a national pastime, uttered in coffee shops, at dinner tables, and screamed into the void of social media. The complaints weren't just esoteric legal debates, they touched on fundamental aspects of American democracy. For instance, the constant questioning of the legitimacy of the press, often labeled the enemy of the people, raised First Amendment concerns. Another major area of constitutional friction involved the concept of executive privilege and congressional oversight. When House committees, controlled by Democrats after the 2018 midterms, sought documents and testimony related to various investigations, the Trump administration frequently resisted. They invoked executive privilege, a doctrine meant to protect internal White House deliberations, but critics argued it was being used too broadly to obstruct legitimate congressional inquiries. This led to numerous court battles over subpoenas, with Congress trying to assert its oversight role and the White House pushing back hard. It was a classic separation of powers tug-of-war, only with more lawyers and less mud. When the constitutional ground started to feel a bit shaky, the legal experts, bless their well-thumbed copies of Constitutional Law for Dummies and Presidents, were quick to weigh in. And by weigh in, I mean, they appeared on every news channel, wrote a gazillion op-eds, and probably debated the finer points of the take care clause at their kids' soccer games. For example, concerning the travel ban, many scholars like Lawrence Tribe of Harvard Law were vociferous in their criticism, arguing it was a clear violation of religious freedom principles, regardless of how the administration tried to frame it purely around national security. On the other side, some legal commentators, often those with a more expansive view of executive power in areas like national security and immigration, defended the administration's actions. John Yoo, for instance, known for his work during the George W. Bush administration, often argued for broader presidential authority. The debates around the emoluments clauses were particularly fascinating for legal nerds. Experts like Norman Eisen and Richard Painter, who served as ethics lawyers in previous administrations, Obama and George W. Bush respectively, became prominent voices arguing that President Trump's business dealings created unprecedented constitutional conflicts. Then there were the discussions surrounding obstruction of justice and the powers of the presidency. These experts emphasized that not technically illegal isn't the same as constitutionally sound or good for democracy. Impeachment. It's the Constitution's ultimate "you're fired" mechanism for a president, though, as we've seen, it's more like a very serious, very public performance review that rarely results in actual dismissal from the job. President Trump had the distinct honor of being impeached not once but twice by the House of Representatives. The first impeachment, in late 2019 and early 2020, centered on allegations that President Trump had abused his power by pressuring Ukraine to investigate his political rivals and then obstructed Congress by refusing to cooperate with the impeachment inquiry. Constitutional scholars lined up on both sides. Democrats and their allied experts argued this was a textbook case of soliciting foreign interference in an election and using the office for personal gain, clear abuses of power. Republicans and their legal defenders, however, argued that the president's actions didn't meet the threshold for impeachment. The Senate, acting as the trial court, ultimately acquitted President Trump on both articles. The second impeachment, in January 2021, was even more extraordinary. Following the attack on the U.S. Capitol on January 6th, he was again acquitted, though more Republicans voted to convict this time. After 4 years of constitutional kerfuffles and legal battles, what's the big takeaway? The U.S. Constitution is more flexible or perhaps more vulnerable than many assumed. The Trump administration pushed boundaries, exposing ambiguities and loopholes where norms, not laws, govern behavior. The impact on public perception of the Constitution and the rule of law is mixed. For some, trust in institutions eroded, while others saw it as fighting an unfair system. This polarization made agreeing on the Constitution's meaning harder. The period highlighted the importance of unwritten rules and conventions in governance. Ultimately, it reminded us that democratic institutions require constant vigilance and active defense.